City of Boerne v. Flores, 521 U.S. 507, was a Supreme Court case concerning the scope of Congress's enforcement power under the Fifth Section of the 14th Amendment. The case also had a significant impact on historic preservation. Facts: the basis for dispute arose when the Catholic Archbishop of San Antonio, Patrick Flores, applied for a building permit to enlarge his 1923 mission-style St. Peter's Church in Boerne, Texas. The building was located in a historic district and considered a contributing property. Local zoning authorities denied the permit, citing an ordinance governing additions and new construction in a historic district. The Archbishop brought suit, challenging the ruling under the Religious Freedom Restoration Act of 1993. Flores argued that his congregation had outgrown the existing structure, rendering the ruling a substantial burden on the free exercise of religion without a compelling state interest. Religious Freedom Restoration Act, RFRA, had been crafted as a direct response to the Supreme Court's decision in Employment Division v. Smith, 494 U.S. 872, wherein the court had upheld against a First Amendment challenge an Oregon law criminalizing peyote use, which was used in Native American religious rituals. The state of Oregon won on the basis that the drug laws were non-discriminatory laws of general applicability. Religious groups became concerned that this case would be cited as precedent for further regulation of common religious practices, and lobbied Congress for legislative protection. RFRA provided a strict scrutiny standard, requiring narrowly tailored regulation serving a compelling government interest in any case substantially burdening the free exercise of religion, regardless of the intent and general applicability of the law. The RFRA applies to all laws passed by Congress prior to its enactment and to all future laws that are not explicitly exempted. 42 U.S. Code is Section 2000 BBA 3, Congress' power to do so was not challenged here. Congress also applied the law to state and local governments, the City of Boerne in this case, relying on the 14th Amendment, in particular Section 5, which says the Congress shall have power to enforce, by appropriate legislation, the provisions of this article. Result: District Court. The City of Boerne was successful at the United States District Court for the Western District of Texas. The judge struck down the RFRA as unconstitutional. Flores appealed to the United States Court of Appeals for the Fifth Circuit, which found the RFRA constitutional and reversed the district court's decision. Boerne filed a certiorari petition to the Supreme Court. The National Trust for Historic Preservation, among other preservation organizations, filed briefs in support of Boerne. Supreme Court. The court, in an opinion by Justice Anthony Kennedy, struck down RFRA as it applies to the states as an unconstitutional use of Congress's enforcement powers. The court held that it holds the sole power to define the substantive rights guaranteed by the 14th Amendment, a definition to which Congress may not add and from which it may not subtract. Congress could not constitutionally enact RFRA because the law was not designed to have congruence and proportionality with the substantive rights that the court had defined. Although Congress could enact remedial, or prophylactic legislation to guarantee rights not exactly congruent with those defined by the court, it could only do so in order to more effectively prevent, deter, or correct violations of those rights actually guaranteed by the court. RFRA was seen disproportionate in its effects compared to its objective. Justice Kennedy wrote, Congress power under a Section 5, however, extends only to enforcing the provisions of the 14th Amendment. The court has described this power as remedial. The design of the amendment and the text of a Section 5 are inconsistent with the suggestion that Congress has the power to decree the substance of the 14th Amendment's restrictions on the states. Legislation which alters the meaning of the Free Exercise Clause cannot be said to be enforcing the clause. Congress does not enforce a constitutional right by changing what the right is. It has been given the power to enforce, not the power to determine what constitutes a constitutional violation. Were it not so, what Congress would be enforcing would no longer be, in any meaningful sense, the provisions of the 14th Amendment. Moreover, remedial or prophylactic legislation still had to show congruence and proportionality between the end it aimed to reach, and the means it chose to reach those ends, that is, the penalties or prohibitions it enacted to prevent or correct those violations. Because our FRA was not reasonably remedial or prophylactic, it was unconstitutional. Implications, congruence and proportionality. Boerne is important for several reasons. One reason is that it introduced a completely new test for deciding whether Congress had exceeded its Section 5 powers, the congruence and proportionality test, a test that has proven to have great importance in the context of the 11th Amendment. Another reason was that it explicitly declared that the court alone has the ability to state which rights are protected by the 14th Amendment. Yet another was that it had First Amendment consequences too, in that it spelled the end for any legislative attempts to overturn Employment Division v. Smith. The congruence and proportionality requirement replaced the previous theory advanced in Katzenbach v. Morgan that the Equal Protection Clause is a positive grant of legislative power authorizing Congress to exercise its discretion in determining the needful nature of legislation to secure 14th Amendment guarantees. Before the 1997 Boerne decision, Katzenbach v. Morgan was often interpreted as allowing Congress to go beyond, but not fall short of, the court's interpretation of the Equal Protection Clause. But that is not how the majority opinion in Boerne interpreted Katzenbach. There is language in our opinion in Katzenbach v. Morgan, 384 U.S. 641, which could be interpreted as acknowledging a power in Congress to enact legislation that expands the rights contained in a Section 1 of the 14th Amendment. This is not a necessary interpretation, however, or even the best one. If Congress could define its own powers by altering the 14th Amendment's meaning, no longer would the Constitution be superior paramount law, unchangeable by ordinary means. The holding of Boerne said that only the court could interpret the Constitution, in order to maintain the traditional separation of powers between Congress and the judiciary. Also, Boerne relied on arguments for protecting the rights that pertain to state governments based on enumerated powers. The intent of Boerne was to prevent a considerable congressional intrusion into the state's traditional prerogatives and general authority. The holding of Boerne specifically mentioned the state action doctrine of the civil rights cases as a court interpretation of the Equal Protection Clause that limits the remedial or preventive power of Congress. Historic preservation. The Supreme Court's decision in City of Boerne made a significant impact on the state's authority to enact and enforce laws, including those pertaining to historic preservation. Under our FRA, an otherwise neutral state law such as zoning, or historic preservation ordinances needed to be scrutinized if its enforcement involved a religious group or individual. Therefore, by declaring our FRA unconstitutional, the ability of the states to establish and maintain historic preservation ordinances was made easier. However, in 2000, Congress enacted the Religious Land Use and Institutionalized Persons Act, in which it used the spending clause to require, for localities that receive federal funding, land use laws to accommodate religious freedom, essentially, as if our FRA had been constitutional. Federal law. The validity of the FRA as applied to federal law was not at issue in this case. The FRA was later upheld for federal law in Gonzales v. O Centro Espírito Beneficente União do Vegetal. See also, List of United States Supreme Court cases, Volume 521, List of United States Supreme Court cases, Lists of United States Supreme Court cases by volume, references. Further reading, Ali, Robert S. The Constitution and Religion, Leading Supreme Court Cases on Church and State. Amherst, New York, Prometheus Books ppA 515 €535. ISBN A1-57392-703-1 External links, text of City of Boerne v. Flores, 521 US 507 is available from, Afindla Wojciecha Elia.